Okay, so welcome back to part two. Now that we've discussed a little bit about how juries are selected, let's start to look now at what happens behind those closed doors. So what factors affect jury deliberations and decision making? Well, when they've retired to start their deliberation process, they can request clarification on law or review evidence. So this means that they can ask for clarification for something from the judge. Most deliberations are not lengthy. Many verdicts are given on a Friday afternoon. In Queensland and New South Wales and the ACT, Queensland's not written there and it should be, it requires a unanimous decision. So all 12 people have to say guilty or not guilty. Other states require a majority verdict. But in Queensland, the difference is that while we require a unanimous decision, if they're not able to get a unanimous decision, then the judge may allow a majority verdict. So what about the research on juries? Well, we know more about psychological process of mock juries than real juries. So in Queensland, to do research on juries, it is actually an offence to publish information about jury deliberations, which is why I said before it was so absolutely rare for those people to get access to the Joe jury to make that documentary, because you can't publish information about jury deliberations. It is an offence to seek information from a juror or former juror. It is an offence for the juror or former juror to disclose information, and the maximum penalty you can get is 2 years imprisonment. So think about in America, and this first came out really big with the O.J. Simpson trial. That's the first one I remember, where the jurors were being interviewed. There are a lot of jurors on really big cases that can go on to make quite a lot of money by appearing on talk shows and discussing what went on in the jury room and discussing the evidence and everything like that. Not here. Can't do it here at all. So where do we get our information on juries to try and do some research? Well, most of it comes from this little list on the right. So archival research, which is looking at court transcripts. Questionnaire surveys, you might be able to send these to the judge and maybe the defence and the prosecution, but just not the juries. Mock juries, which we'll talk about, they are an artificial setup of a jury. Shadow juries is a good one because this is 12 people who sit in the courtroom and they hear exactly the same information as the jury, but you can then tape them doing their deliberation to find out how they reach their conclusion and see if they match up with the real jury. The problem with doing that is that every time the jury gets sent out during the trial for maybe some sort of debate going on with the judge and the prosecution and the defence, then the shadow jury has to leave too, so that you don't taint your research by them getting information or hearing something that the real jury doesn't hear. And post-trial juror interviews where this is allowed, and it's not allowed here, so you can't do it. Okay, so jury decision making, because yes, that's what we are still discovering. What is the limitations with jury simulation research? Well, the researchers quite often lack legal knowledge, so the scenarios that they might develop for a mock jury can be really unrealistic. They might have all the details about a case, but without legal knowledge, it's never going to be exactly the same. And keep in mind too, that quite often cases in court can go for weeks and weeks and weeks, and you can't do that with a mock jury where you bring people in day after day after day after day to try and run it exactly the same as it happens in court. The written hypothetical cases are often simplistic versions of real trials, and more recent audio-visual versions tend to be short, because as I just said, trials can go on for weeks or even months, so the simulation is not accurate. Use of students as mock jurors. So a lot of this research is done in universities, so naturally students quite often get used as being the mock jurors. Unfortunately, guys, you are not representative of the entire population. I would no more try to be representative of you than you should try to be representative of me, because we're different generations. So using students as mock jurors is not representative of the entire population. A lack of acknowledgement of differences between actual jury research and mock jury research. So not acknowledging that the research that they do is not based on real events. Jury research often assesses decisions of individual jurors rather than the verdict as an outcome of jury deliberation. And you can't look at the decisions of individual jurors because this is a group process. This is a group of people making a decision together. And the likelihood that research will improve the system is highly questionable because it's not going to improve the system with a mock jury containing students. And one of the biggest problems that is faced, as I discussed earlier, how can you get people to be able to sit on juries who are representative of the population? So this study looked at about 1,000 defendants on felony charges in Indiana. So 2/3 of the cases involved trial by jury. This lady looked at the file folders of the assistant prosecutor, police arrest records, telephone interviews, and did all of that to obtain any necessary supplementary data. As she was on the prosecutor's staff at the time she did this research, she was also able to conduct informal discussions with prosecutors and court personnel. So what are the things that a jury is influenced by? They're influenced by a weapon being recovered. A large number of witnesses. So if there's a lot of people that are going to come forward and give testimony of what they know, then they're influenced by that. Statements concerning the involvement or lack of involvement of the defendant in the crime. If the defendant had any previous convictions. Now, keep in mind this research was done in the US. In Australia, the jury would not know that because they are being tasked with judging guilt or innocence only based on the case that is in front of them, and having knowledge of previous convictions can taint their decision. Whether the defendant was unemployed can influence them. If the victim was young, they'll be influenced by that. And less serious crime. So how serious was the crime? What they're not influenced by, and this flies in the face of what we learned in eyewitness testimony, is eyewitness identification. So sometimes jurors are not always influenced by eyewitness identification. They're not always influenced by expert testimony. They're not always influenced by the fact that the stolen property has been recovered. They're focusing on what the defendant actually did, not whether the property's been covered. They're not influenced by their criminal history or relationship. And don't forget, you can have a criminal history without actually having a lot of convictions. You can have gotten off stuff. And they're not influenced by the past conduct of the victim, so how they've behaved in the past, as in their conduct, not necessarily their criminal conduct. So don't forget, there is much importance placed by researchers on eyewitness testimony and expert testimony. So eyewitness identification and expert testimony. That's the researchers putting a lot of, focus on those things, whereas jurors that were real jurors were actually not as influenced by that. So what does the role of defendant characteristics play? Isn't he a good looking little chappy? Now, if you saw him come up in the box, have a think to yourself, what would be your first thought about this gentleman if you were on the jury and had to make a decision? So physical attractiveness actually matters. It may reduce guilt and punishments. However, jurors will always be harsher on an attractive defendant if they use their looks to commit the crime. And if they didn't use their looks to commit the crime, then they're more likely to be found guilty. Social attractiveness, so whether people have higher social status, that will relate to a lower likelihood of a guilty verdict. So if they're very important people with high-flying jobs, they're less likely to be found guilty. And we've talked about that a lot when we talked about things like white-collar crime and internet crime. People who are high flyers and seem to be a little bit above the rest of us, because they've got more money to pay for really good defence, they sometimes, or a lot of times, are able to either get off altogether or get a lower punishment. And attitudinal attractiveness. So this is where the juror finds that they think the same way as the defendant. So if it comes out during the trial what the defendant's political or life views are, if the juror finds that they are attracted to that attitude and thinking the same way, they might be less likely to find them guilty. And if they do find them guilty, give a reduced sentence. What that means is in America, juries play a role in sentencing as well. Of course, here they don't. So the role of defendant characteristics. So criminal history. If a person on a rape charge has already been convicted of rape, then they're more likely to be found guilty. In America, where the jury can find out. In Queensland, criminal history cannot form part of the evidence except in exceptionally rare cases. So what is the courtroom behaviour of the defendant? Well, we expect them to behave, and the media has a big role to play in this. We expect them to behave a particular way. So you'll find them guilty, or the jury may find them guilty if they don't behave as we think they should. So for example, if they're extremely defensive, or if they just shrug their shoulders and don't seem to care. Two really, really good examples of this are Amanda Knox. So when she was in court in Italy, she used to laugh and joke a lot, and the Italians thought that that was really, really inappropriate behaviour and said that she was not behaving as she should behave for someone who was in that situation. And she explains in her book that she was behaving like that because, one, she was extremely nervous and scared, and it was just a reaction to those feelings. And two, because she knew she didn't commit the crime, she thought that this really couldn't be going anywhere and that it would finish soon and she'd be gone. The other really good example in Australia is Lindy Chamberlain. So when her daughter Azaria was taken by the dingo at Ayers Rock, she didn't behave to the media the way the media thought that she should behave. She was quite stoic. She didn't cry in front of the cameras. She was quite composed. And honestly, she got absolutely slammed for that at the time. I remember that well too. Sorry, just grabbing a mouthful of water. Okay, so we as a society have these set in concrete beliefs and thoughts about how we think people should behave when something goes wrong. And as we know, people are all different. How I'm going to react to something really bad could be different to how other people are going to react. We all have our different ways of coping. So what's the role of juror characteristics? Well, the research did find that female jurors are more likely to convict in relation to rape and child abuse. Hardly surprising. I would think that a lot of men would convict with child abuse too. Younger jurors are more likely to acquit, except if they're highly educated. And if they are highly educated, they're more likely to convict. There's conflicting findings about conservatism. So some studies find that conservative people are more likely to convict, and others say the opposite. So the findings about people who are quite conservative is conflicting. And juror authoritarianism relates to more severe sentence, but not probability of conviction. So what this means is that you might want them to have a really, really harsh sentence, but in Australia, as a juror, you can't control that simply because juries don't have a role in sentencing. Does pre-trial publicity prejudice trial outcomes? Well, there are very few cases that receive really widespread media attention, but some that you can think of, or I could think of and suggest to you, would be O.J. Simpson, which actually ended up the O.J. Simpson trial having a dedicated 24/7 TV channel just to the trial. Brett Cowan, who killed Daniel Morcombe, absolutely huge media attention. Gerard Baden Clay, so you should all know about Gerard Baden Clay. And Jayant Patel, who was nicknamed Dr. Death, he received huge attention in Bundaberg over the number of people that he killed during surgery and who have got ongoing permanent medical issues from his surgeries. So they had to move the trial to Brisbane to try and find a jury a little removed from the attention that he and the case have received. So pre-trial publicity can make it potentially prejudicial to the person getting a fair trial. The murder of the Singh children in Brisbane, going back a long time ago now, and I cannot remember the name of the guy that did it, but if you wanted to find out, just Google the Singh murders, S-I-N-G-H. 3 siblings were found murdered in their home and their bodies were left in the hot tub and the hot tub was left running. And this guy was actually putting himself forward to the media for interviews and saying, I'm the prime suspect, I'm the prime suspect. Well, in the end, yes, he was the prime suspect, and he's good buddies with Gerard Baden Clay now because they're both in protective custody. He ended up being able to get a judge-only trial because his defence was able to argue successfully that with the amount of pre-trial publicity, he would not be able to get a jury that didn't know more than they needed to know about the case already to give a non-biased judgment on him. Okay. All right. So as I said before, it's not only about individual jurors, it's about the group processes that are at play within the jury room. And here are the 2 different deliberation styles that I mentioned we would be talking about. So the first deliberation style is where you have a jury that is very verdict driven. They just want to get a verdict as soon as possible, especially if they are sent away to start their deliberating late in the week. They would just be wanting to get it over and get it done with so they can go home, enjoy their weekend and not have to come back. This is where majority decision juries come into play a lot more because they tend to be more verdict driven. If we can get 10 people who vote one way or the other, great, we're done, and we can go. The other deliberation style is the one that is evidence driven. So this is the jury that is going to focus a lot on discussion and evaluation. They're going to look back all over the evidence and deliberate longer. And these are the people who are going to have greater satisfaction with the jury decision-making process. And these tend to be unanimous decision juries, where they have to try and get all 12 people on the same page and voting the same way. So they tend to be more evidence-driven juries. The timing of the ballots. So the ballot is when they first walk back into the jury room, how long before they take a vote. Calvin and Ziesel in '66 found that there was a significant relationship between first ballot votes and final jury verdict. So in most of the trials that they studied, the juries waited 45 minutes discussing the case before taking a first ballot, while 11% of trials, the jurors had a ballot without any discussion taking place. So they just walked straight back in, sat down and said, let's take a ballot and just see where we're sitting. Okay. Davis et al. In '88 found that the timing of the straw poll on individual first ballots before any discussion versus after 5 minutes of discussion significantly influences how jurors will change their initial verdict preference. So whether you do it before any discussion or after 5 minutes can affect initial verdict preference by some jurors. So what is jury decision making a function of? Well, the characteristics of individual jurors, because remember, as I said back at the beginning, we're putting 12 people together who don't know each other and expecting them to all come up with the same answer at the end, as it were. So how is each individual juror able to attend to, interpret and remember evidence? We're not all the same. Everyone's going to have different abilities in staying focused, interpreting what's happening in the courtroom and remembering what's happening. And the heuristics are the expectations about how people are supposed to act and inferences drawn from witness and victim behaviour. So remember, I discussed that with Amanda Knox and Lindy Chamberlain. this is the expectations from the jury about how witnesses and the victims are supposed to act. Group processes are interactions and discussions between two or more jurors. That then becomes a group process. Research by Ellsworth found that men talk more than women, and the foreperson talks a disproportionate amount of time. And the length of deliberation, tendency for minority jurors to move closer to the majority view over time. So if you've got only a couple of minority jurors on the jury, they would be more likely to move closer to what the majority view is over time. And the number of minority jurors will affect that decision. I want you to watch this video on Ash's experiment and just see how easy it is to get someone to conform and change their mind, even though they know that they are right about something and the group is wrong. So I'll just do the last 2 points before you go off and do that. The timing of the ballots, as we discussed, as in this is a group process, but is heavily influenced by the foreperson. So when they walk back in from the jury and sit down, the foreperson may be the first person to talk and say, we'll do a poll straight away, or we'll wait 5 minutes or whatever, and then a discussion will ensue. Larger juries and a requirement for a unanimous decision is more likely to result in a hung jury. So our jury size here is 12. That's just what we have in Australia. In other places, they have different jury sizes and they have different rules about making decisions. But the larger your jury, and if there is a requirement for it to be unanimous, it's more likely to result in a hung jury. Please go back and watch that YouTube clip now about Ash's experiment. Okay, what we've just talked about in group processes about taking a vote and everything, I want you to watch this video now, this section of the video anyway, that comes from Joe's jury, and it shows what happens immediately after they walk back into the jury room at the end of the trial. Okay, acquittals. So again, acquittals when the jury has found the defendant not guilty and acquitted them of committing any crime. In Queensland in 2010-11, the higher court adjudicated outcomes for murder, 28% of defendants were acquitted and 20% of defendants were acquitted for sexual assault. In 1972, McCabe and Purves surveyed solicitors and judges about 500 trials. 25% of prosecution counsel and 1/3 of judges were dissatisfied with the jury's verdict. 12% were perverse outcomes. So perverse acquittals and perverse outcomes is where the jury's verdict is really, as it says down the bottom, against the weight of the evidence. Okay, so that's something that you need to keep in mind, that the jury may not always come up with the outcome that the judge and the prosecution actually agrees with. They may come up with a different outcome altogether, and this is called a perverse outcome or a perverse acquittal. And you can link some of that back to what people see on TV. I know that these studies were done well before the CSI effect would have been in place, but remember that sometimes juries are looking for specific information and they don't always get it. So if you want to know a little bit more, there's an Australian documentary records the jury deliberations of 2 juries deciding on a murder case. That's called Secrets of the Jury Room, and it's available in the library. I'd also have a look online because you are likely to find some of this stuff online now. So that's called Secrets of the Jury Room. Okay, in summary, juries are used relatively infrequently. They're only used in the Supreme Court and District. Researchers encounter many problems studying jurors due to legislation preventing the discussion of the juror deliberation processes, which is why a lot of juror research will come out of the states where they can actually talk to jurors. Research on jurors based on the simulation of cases has been criticised. A number of factors external to the case can affect jury decision making, including those group processes. And research on scientific jury selection is limited and has not conclusively identified its value. All right, that's the end of part 2 and the end of the subject matter for this week. In week 11, we will be doing assessing risk and dangerousness. I'll see you in tutorial.